think I promised in the first episode that some CPO content was on its way, so here it is. I'm going to discuss the Upper Tribunal decision in Secretary of State for Transport and Curzon Park Ltd. The decision is dated the 23rd of January and it relates to 4 sites in Birmingham that were compulsorily acquired in 2018 for the new HS2 station. The compulsory acquisition was implemented by separate GVDs, and the 4 sites vested in the Secretary of State between March and September 2018. After the last of the vesting dates, each of the 4 respondents applied to the local planning authority, Birmingham City Council, for a certificate of appropriate alternative development. All 4 sites are close to the main campuses of 2 universities, and in all 4 cases the certificate sought was for a mixed-use scheme, including provision for purpose-built student accommodation. Each certificate application, though, was self-contained, so it related only to development of the applicant's site, and it didn't take into account development on the other 3 sites. The Council accepted the respondents' argument that in determining any one of the 4 applications, the other 3 should be disregarded, so it considered each of the applications in isolation. 4 appeals were made to the Upper Tribunal, 2 brought by the Secretary of State against the certificates granted by the Council, and 2 brought by respondents for non-determination of their applications. The Secretary of State argued that the Council should not have considered the applications in isolation from each other, and that if it had adopted the right approach, then the certificates granted would have described development of some or all of the sites on a much smaller scale, so the compensation payable to some or all of the respondents would likely be reduced. The question for the Upper Tribunal was whether, and if so how, the decision maker in determining an application for a certificate may take into account the development of other land where that development is proposed as appropriate alternative development in another certificate application arising from the compulsory acquisition of land for the same underlying scheme, and that's whether the application has been made or determined. The Council's officers had advised that because the statutory scheme requires it to be assumed that the project was cancelled on its launch date, no certificate applications by neighbouring landowners could have been submitted, so there was no requirement to consider the cumulative effects of the 4 applications. The Upper Tribunal rejected that argument and concluded that Section 14(5)(a) only requires the scheme to be taken as having been cancelled, so it does not extend to requiring the other certificate applications to be disregarded, and nor does Section 14(5)(b) have that effect. So in the view of the Upper Tribunal, the certificate applications made in relation to adjoining sites were beyond the scope of the cancellation assumption. One might query whether the position would be different if the certificate application were made by an acquiring authority, but the Upper Tribunal considered that to be an esoteric point that did not arise in the appeals. Now, personally, I initially found the Tribunal's reasoning on this point somewhat surprising, but the justification for it comes at paragraph 46. The Upper Tribunal also reasoned that a decision to grant a certificate in respect of an adjoining site would not be of any relevance to a real-world application for planning permission, but the outcome of a certificate application in relation to adjoining site might be relevant to the determination of a certificate application in relation to the site itself, because it is capable of being relied on as evidence of how, in the no-scheme world, the local planning authority might reasonably have been expected to deal with an application for planning permission on the site. However, a mere application for a certificate for an adjoining site is, in the Upper Tribunal's view, unlikely to be of significance, but the weight to be given to a certificate application or to the outcome of that application as regards an adjoining site is in any event for the decision maker. The Upper Tribunal did not accept the Secretary of State's argument that the Council's approach would result in excessive compensation, with each landowner winning a jackpot that in the real world would have had to be shared between them. The Upper Tribunal reasoned that we can't know what value the land would have had on the valuation date if the scheme actually had been cancelled on its launch date. One or more of the landowners might have obtained more favourable planning permission than the others, but we can't know which would have done well and which would have done badly. So the answer given by the Upper Tribunal to the preliminary issue is that in determining the application for a certificate of appropriate alternative development, the decision maker is not required to assume that certificate applications or decisions arising from the compulsory acquisition of other land for the scheme had never been made. Such applications and decisions must be treated, says the Upper Tribunal, as what they are. They're not notional applications for or grants of planning permission, and they're not material planning considerations, but subject to that, the decision maker can give such applications and decisions whatever evidential weight it thinks is appropriate. That's everything for episode 3. I hope it's useful, and take care.